The first meeting is really a get-to-know-you meeting. We're going to sit down. Typically, the meeting will last about an hour. We're having a conversation. My job is to ask them some questions about where they are, what some of their goals are, what some of the key objectives they have in meeting with me, where they are to this point, and really what brought them in to see me. And now I'm at the point in my career where I have a lot of people that are dependent upon me to provide them with all the guidance and all the advice that we do on a day-to-day basis.
You spend your working years trying to build up your assets, trying to build up pension credits at your job, trying to grow your nest egg so that you can one day retire when you can't work or don't want to work anymore. And that's a period followed by phase two, which is retirement. And your priorities in these two phases are very different, but many times we see people don't make that shift and they still act like they're in phase one when they really should be acting like they're in phase two.
We're going to talk to you about what we commonly refer to as the second half of the game. And what I mean by that is you're working your entire life towards retirement, and I'm assuming that most of you are, at that age where you're starting to consider some of your options as you move into retirement. And as you do that, you're moving from what we call the accumulation phase of your life, where you're accumulating your assets. Maybe you're participating in your company's 401k, maybe you're contributing to an IRA account or a Roth IRA account or some type of retirement vehicle. And now, as you retire, you're transitioning into the distribution phase, or the part where you're going to need income in retirement. So we're going to talk about some different ways to do that with an emphasis on Social Security.
Hi, and welcome to Financially Speaking with Jeff Bush. My name is Barry Warnker, and I'll be the host of tonight's show. And tonight we're going to be talking about common inheritance mistakes. Mistakes that are made for people when people leave money behind, assets behind, and mistakes that the inheritors can make. And we're going to talk about them with my partner, Jeff Bush.
Well, hello, Barry, and welcome to the show. First, let me say it's great to be here on PCTV. You and I have been doing this now going on 3 years, and we're grateful to have this presence not only in the Pottstown area, but also via the World Wide Web, not only on our website, but also the PCTV website. So a big thank you to all our friends here at PCTV. Today we're going to talk about inheritance and some of the more common mistakes.
Well, let's kind of kick it off with a strange example, but it's a helpful and good learning example of how these things can go wrong. A lot of people assume, you sign a form here or there, and these things are taken care of. But it can be a lot more complicated than that. There was a case that became famous not that long ago. They called it the pension pickle. And that was a case where over $1 million really kind of went to the wrong person when someone passed away.
Yeah, that's right, Barry. The wife was a retired school teacher. Each year, the retirement system sent out a statement that indicated that there was no named beneficiary. So the husband automatically thought, since he was the closest relative, that he would be the beneficiary. But unfortunately, after she died, officials found a form that had been completed 27 years earlier, before the couple had even met. And it indicated that her mother, her uncle, and her sister would share equally in the inheritance. Since the mother and uncle had died, the entire amount was subsequently awarded to the sister.
So the sister got the money, and I remember this case because I think the woman who passed away and her sister, they had fallen out. They hadn't spoken to each other, I think, in 20 years. So here's the husband, who the poor lady who passed away, her husband, who she wanted to leave her assets to, and this being probably the biggest one they had, over $1 million, goes to her sister, who she care if whatever happens
Right,
to her.
they weren't on speaking terms.
And,
That's
and that
right.
just shows you that there's some things you need to think about and take care of while you're still here among us.
Yeah, I mean the system was it was fought in court, and it was upheld because of the document was deemed to be official. So the sister ended up with the money, and the widower was left with nothing.
So I know often in our practice at Inform Family, where we're helping people do their financial planning and helping them develop and maintain great retirements, that one of the first things we do when we meet with folks is to review their beneficiaries. Oftentimes they think it's taken care of, but
Yeah, the easiest thing to do is to periodically check your beneficiary statements and make sure they're up to date. When we get a new client into our system, that's one of the first things that we do is we check all the beneficiaries just to make sure they're up to date. And we find, you find mistakes. You find, people that are named as beneficiaries are already deceased. We find divorce in the case of some divorces where they've named the ex-spouse is still on the form as the beneficiary. So we find all kinds of things, but it's important to do that review. People get caught up in life, and sometimes these things fall through the cracks. So one of the things we do is make sure that these are all up to date.
I know many times we'll be sitting with a couple and they'll say, well, we have a will, because we'll ask them, and their will may have been drafted 10, 20, 30 years ago. Oftentimes people have a will made maybe when a life event happens, when they get married, when they have a child, that type of thing. But things need to be reviewed and looked at, and the will can leave assets to people. It can also be done by contract. But one of the things people often ask is, how do they get money to children? And the children maybe aren't of age yet. How's that handled?
Right. Well, most states have limits on the amount of money a minor can directly receive through inheritance. In most states, a minor is like 18 or younger, or I should say younger than 18. The limit is usually quite low, about $5,000. If the inheritance is more than this, the state is going to step in and require that a custodian be named. They're going to also require that a trust be established. And of course, an easier solution would be to name a minor where they call them UTMA accounts, which stands for Uniform Trust to Minors Act. And you can actually set up one of these, we call them UTMA accounts. And it's a way to set up an account for a minor without actually going through the expense and the hassle of setting up a trust.
So one of the things people should keep in mind is, if you have children, you want to check your will and check your insurance to make sure that they're, if you want to name them, that they're properly named. If they've transitioned from being minors to being adults, you may need to have things changed over. So as time goes by, these things should probably be looked at every 3, 4 years, 5 years, or especially after some family type event, birth, death, divorce, whatever. So now a lot of people don't understand. They'll say, well, I've taken care of where my money goes when I die because I have a will. But the will you can pass assets via your will, but not all assets will pass via a will, and other assets have to be handled differently.
Yeah, that's a common mistake. The will is really designed to handle what we call the probatable assets. There's another way to pass assets on to heirs, and that's through named beneficiaries on a contract.
Back up for a second, though, Jeff. Cause the first part of what you said, a probatable asset. That's a mouthful, and many people may not know exactly what you're
right.
talking
Well,
about. Well,
what that means, probate means that. So let's just say, for example, the state of Pennsylvania. When you have probate, it means that your assets pass through your will. So it's designed to catch things like your house, your bank accounts, your car, any asset that you own but doesn't have a named beneficiary. So the distinction that I want to make is that there are certain things like IRA accounts, life insurance, annuities, where you've got a named beneficiary right on the contract. So if you have an IRA, you will name on your IRA a beneficiary. So if you're married, you would name your spouse, as an example. So what that means is that you don't receive that asset through the process of probate or your will, the processing of your will. It's done through the operation of the contract, which means you've named your beneficiary on the IRA.
So that's important for a couple of reasons. Number one is, if you really want this asset to go to the person that you're naming, if you can do it through passing it through a life insurance policy, through an annuity, through an IRA, you've just saved a whole lot of time and expense. That asset's going to go to that person in a matter of a week or two, as opposed to something that's left via a will, which could take anywhere from a couple months to longer, because wills can actually be disputed, and we've seen that happen.
Yeah. So again, let's say Pennsylvania, and again, it has to do with how complicated the will is.
Sure.
You know, there could be if there's property. That usually what holds up the processing of a will is selling the house. Mm-hmm. So if you own real estate, your house, you have to sell the house, and that's usually what takes the longest. But that ties up everything in the whole process. So in other words, anything that's in this this probate or in the operation of the will is tied up until everything gets settled.
And let me just mention one thing quickly. We want to make it clear that we're not a law firm. We don't practice law, but we are involved with people in their lifetime, and oftentimes we're called upon to explain things, and we want to make sure our clients understand how wills work. But if you're going to do anything with a will, make sure you do it with a licensed attorney.
That's a good catch, Barry. That's a good. In the interest of full disclosure here. Yeah. So there's plenty of competent attorneys around, and we can certainly help you find one. But and it's certainly to do a simple will, or if you need some more advanced planning, whether it's elder law or maybe special needs or whatever it is, we can help you find a lawyer.
By the way, I had an uncle who promised to remember me in his will, and when he died and they read the will, it said, "Hi, Barry." So he did remember me in his will, but he didn't remember to leave me anything. And there are cases where people will write in their will they're leaving this large sum of money or this, and they don't even own it.
Yeah.
Maybe it no longer is theirs.
You know, and the fact of the matter is that, you know, we talk about these other assets like the life insurance and the IRA account. Sometimes they're bigger dollars than what's in the actual the will itself. So that's why it's important that we talk about this. With the IRA, it's important to have a named beneficiary for a lot of reasons. A lot of reasons.
Yeah,
First of which is you want your spouse to inherit the IRA, so the IRA now becomes the IRA of the spouse. So it's called a spousal IRA, but it preserves all the tax benefits. Now, here's another interesting twist with respect to IRAs, and that is contingent beneficiaries. That's also very important. Contingent beneficiaries, often missed. What's a contingent beneficiary? A contingent beneficiary is someone who's standing second in line. So if let's use the example of a husband and a wife, and they have 2 children. The husband has an IRA account. In most cases, the husband is going to list his wife as the primary beneficiary.
Sure.
So she stands first in line. And he's going to name the two children as contingent beneficiaries. Why is that important? Well, it's important because what happens if the wife predeceases the husband? If the wife predeceases the husband, then the IRA automatically goes to the two children, and they inherit the IRA. It's actually called an inherited IRA. So they inherit the IRA, and they inherit all the tax benefits, the tax deferral, more importantly, that goes along with that. The other thing would be if the husband and the wife die in a common disaster, then it automatically reverts to the children. So we don't want to miss that step. You always want to name contingent beneficiaries in the event that the primary beneficiary is not there to receive the benefit.
So, well, tell people what can happen then. You know, they got a case where it's a husband and wife, and they leave their IRAs to each other should something happen. But unfortunately, maybe they pass away together, and there's no contingent beneficiary listed. They didn't think about that. What happens to that money?
Well, in that case, it reverts to the will.
It's okay. And
then in other words, it goes into the estate, it goes into probate, and then it goes through the operation of the will. So then, as we said earlier, it's going to get tied up in the estate. But more importantly, in an IRA account, you have tax features in there. So let's say that all the money in the IRA account is untaxed. So once it goes through the will, then it immediately gets taxed. So you lose the tax benefit of having the IRA.
So you're talking about, a case, let's say it's $300,000, just because there was no contingent beneficiary named, this IRA money had to be sent through probate system, which triggered, probably in that case, $100,000 or more of taxes. Could lose a third or more of the money.
So the example that we just gave with the husband and the wife and the two kids would eventually get the money, assuming that they were named as the beneficiaries in the will. They would still get the asset, but now they're forced to pay taxes on it right away. So let's say that's, in your example, they get $300,000, but now it's split into, it's $150,000 each, but now they got to pay the tax on it because now it's no longer an IRA. So that's just a little bit about, we could spend a whole show talking about IRA beneficiaries.
Well, there is one simple thing that can be done, and in reviewing, you should review any life insurance policies you own, any annuities you own, any IRAs you own. You should renew the beneficiaries on a regular basis. And here's one thing that can be done. Because we've seen this happen where money is, let's say there's two children that receive an inheritance, and they each have, say one has a child and one doesn't have a child. And then one of those two children passes away. You can have a problem because typically what happens when money is left to two named beneficiaries, it's split, maybe split 50-50. But if one of those beneficiaries dies, the survivor gets all the money. Well, what about the children of the beneficiary who died early? So it's very simple when you review these life insurance policies, annuities, IRAs. It's very simply say, I'd leave it to John Jones, if that's the son, per Stirpes, because that will ensure that money, that portion of that beneficiary's money, would go to that beneficiary's children, rather than across to the other child or to a spouse.
Well, now you're getting
a little technical.
Now you're getting into another part of our show here today.
Oh, good.
And that is because one of the questions that you were going to ask me, and I know you were getting to this, is some of the Latin terms that you would use in the naming of beneficiaries. And there's two terms. One is called per Stirpes, and the other one is called per capita.
Okay.
Okay. So let's use an example. So let's just say the case of my parents, my mom and dad, have a will, and there's 3 children. There's me, and there's my brother and my sister. So there's 2 ways for them to pass their assets on to their children, and one is per stirpes. Per stirpes means that it's a Latin term meaning that it follows the roots of the tree. So, in other words, in this example, my brother, my sister, and I are 3 equal shares of this inheritance from my parents. So, if my parents die, and let's use the example where I've already been deceased. My share will go equally to my 4 children. Okay, so I get a third, but since I've predeceased my parents, my share goes to my 4 children. That's per stirpes. There's another way to do it, and that is per capita. So per capita means it's per head. Okay, so per head. What that means simply is if I'm deceased,
Your head's no longer there.
my head's no longer there, and my share simply gets eliminated, and then my brother and my sister would share equally in the inheritance. So in this example, they would each get half. It's a good thing that you brought that up, because that's an important distinction here. Because if you think about it, it's the difference between my brother and my sister getting 50% each, or my brother and my sister getting a third each, and then my children sharing in the other third. Okay? So these are conversations that we have with our clients every day. So for our viewers out there, these are conversations you want to have. And these sometimes are unpleasant conversations, and there's second marriages, and there's all that in
It can
there.
get complicated, yeah.
And it gets complicated, but these are conversations that you want to have, because you don't want people squabbling over this after you're gone. So you want to be very clear about how the inheritance is going to go. All right. So in this case, so now we've identified 2 important concepts here. One is that we want to make sure that we list contingent beneficiaries. And then second, we want to make sure that we've listed the beneficiaries either as per stirpes or per capita.
So that's important stuff, and these are the kind of things that people sign a few forms, and then as you mentioned earlier, Jeff, life gets busy. We're going about our business, and before you know it, a number of years have gone by, and if you don't review these things, you can be doing yourself and the people you care about a great disservice, because they do need to be reviewed. They do need to be checked. Oftentimes, when we review, and we'll be happy to review anybody's life insurance policy, any annuities, any IRAs. We'll be happy to review those. Anybody who doesn't have a will, we'll be happy to recommend a number of attorneys that we've worked with that we feel comfortable with. But this is a very important stuff, because you work your lifetime to achieve a certain financial position, and these are things that should be looked at. And you can feel free to contact us. You can call us at the number above on the screen, or email us at info@informedfamily.com. We love to hear from people. We'll be happy to provide that service. It's a great thing to do, and it's a great way to meet people. So don't be afraid to give us a holler. I know we've covered a lot of ground here today. We wanted to cover the most common mistakes that people make with their planning their inheritance, and there's also a lot of other areas that we cover. Talk to us a little bit about what we do in our public seminars.
Yeah. Well, our seminars, which we have a couple seminars coming up. You can see there on the screen, and you can call call our office or email us, and we'll get you some tickets. We're going to be here in the Pottstown area coming up, and then closer to our other office, which is down in the Jeffersonville area. And in that seminar, we cover a variety of topics. It's really centered around income planning. We touch on Social Security, which is such a hot topic right now. So it's really a lot of information. We take our show on the road, so to speak, and it gives. I know people see us here on TV, but if they want to see us live, it's a good chance to do it.
The seminars are a lot of fun, and people get to learn some things in an interesting and entertaining format. And we don't sell anything. There's nothing for sale there, but we love to see you attend those things.
Yeah, there's an important point that I want to make here as we talk about inheritance and beneficiary mistakes, and it's important to talk about retirement accounts because when it comes to retirement accounts, it's really important to name beneficiaries because if you don't, it creates a few potential problems. Number one, if you don't name a beneficiary on your IRA, the asset is going to go to an estate rather than an individual. And it could be subject to a much higher tax rate. So I wanted to make that point. Number two, these assets are now going to be subject to probate, which can be a long, expensive, cumbersome process, probate. Probate is something that we want to avoid if we can, and you can avoid it if you have a named beneficiary. The other concept is the ability to stretch the IRA over the beneficiary's lifetime. We touched a little bit about the children inheriting the IRA, but the real important feature of that is that the children will be able to stretch the payments from that IRA over the course of their lifetime. So if you have a 40-year-old inheriting an IRA and they're going to live, let's say, another 40 to 45 years, they're going to be able to stretch those payments over their lifetime and the tax liability over their lifetime. So the stretch out IRA, which is something we spend a lot of time talking about, is really important. So you want to make sure that you've got the beneficiaries listed on your IRA account and the contingent beneficiaries on your IRA account. So with that being said, we're going to sign off here today. This is another show that we had a chance to talk to our viewers about important concepts here on Financially Speaking with Jeff Bush, and we'll see you next time.